I now request the President to accompany the dignitaries onto the dais. Distinguished Chief Guest of the evening, Honorable Judge K.V. Viswanathan, Honorable Judge, Supreme Court of India, A.J. Desai, Honorable Chief Justice, High Court of Kerala, K. Gopalakrishna Kurup, Advocate General of Kerala, President Yeshwanth Shenoy, Anoop Nair, Secretary, Balaji Moorthy, sir, Mr. K. Shankar, Advocate Roy Chacko, we acknowledge the presence of family and all the well-wishers of T.S. Krishnamurthy ISR. We start the function with the tradition lighting of the lamp. I request all the dignitaries to light the lamp. Thank you all. Today, it is the proud privilege of Kerala High Court Advocates Association to welcome the distinguished chief guest of the evening, Honorable Justice K.V. Viswanathan, respected Judge, Supreme Court of India. So we are indeed honored with your gracious presence, and we are eagerly looking forward to hear your insight on this topic. To invoke the blessings of God Almighty, I now invite Lakshmi Meenakshi for the prayer song.
शान्ताकारं भुजगशयनं पद्मनाभं सुरेशं विश्वाधारं गगनसदृशं मेघवर्णं शुभाङ्गं लक्ष्मीकान्तं कमलनयनं योगिहृद्यानगम्यं वन्दे विष्णुं भवभयहरं सर्वलोकैकनाथं वन्दे विष्णुं भवभयहरं सर्वलोकैकनाथम्.
Now I invite Anoop Nair, Secretary, Kerala High Court Advocates Association, to welcome the August gathering.
A very good evening to you all. Honorable Judge of the Supreme Court of India, Mr. Justice K.V. Viswanathan, sir. Honorable Chief Justice, Mr. A.J. Desai, Chief Justice of High Court of Kerala. Honorable Judges of this court, Senior Counsels, Members of the Bar, distinguished guests from the family of Honorable Justice TSK lyer, sir, and all others who have gathered here. Good evening and welcome to this solemn occasion where we gather to pay the tribute to the life and legacy of Justice TSK lyer, former Judge of the Kerala High Court. It is an honor to see so many esteemed members of our judicial community here today. Today, we come together to celebrate the indelible mark a remarkable individual left on our lives, our profession and our society. Justice TSK lyer was more than just a brilliant legal mind. He was a beacon of justice, integrity and compassion. We are privileged to be joined by some of the most distinguished members of our judiciary, whose presence here underscores the significance of today's event. Your honors, your attendance is a testament to your unwavering commitment to the advancement of our shared goals and values. First and foremost, I am honored to welcome our esteemed Chief Guest of the day, Honorable Mr. Justice K.V. Viswanathan, sir, Judge, Supreme Court of India, who is a remarkable jurist and a beacon of justice with his legal acumen and profound understanding of law. His judgments are not only a testament to his intellectual rigor, but also reflect his deep empathy and dedication to upholding the rights and freedoms enshrined in our Constitution. Sir, I welcome you to this function. Now I am honored to welcome Honorable Mr. Justice A.J. Desai, Chief Justice of High Court of Kerala, who is a man that needs no introductions for us. His support and guidance has helped this legal fraternity grow to greater heights. I welcome you, sir, to this function. I also welcome all the honorable judges of this honorable court who has graced us with their presence in this auspicious occasion. I welcome all the honorable judges who are present here to this function. Now I welcome Shri Gopalakrishna Kurup, Advocate General of Kerala, to this auspicious occasion. I welcome you, sir. Now I welcome Mr. Yeshwanth Shenoy, President of Kerala High Court Advocates Association, who has tirelessly worked to make this function a grand success. I welcome our President to this function. Now I welcome Shri Balaji K. Moorthy and Mr. K. Shankar to this auspicious occasion, and without their support, this program would not be achievable. Sir, we welcome you to this function. It's my pleasure to welcome the Registrar General, Registrar Administration, and other dignitaries who are present here from the High Court to this occasion, who has extended heartfelt support for organizing this program. Now I am pleased to welcome the senior counsels and all the members of this bar who are present here to this grand occasion. I also welcome Advocate Roy Chacko sir to this function. And I also welcome all the High Court staff and all the members of Kerala High Court Clerk Association to this auspicious occasion. I am also pleased to welcome the family members and well-wishers of Justice T.S. Krishnamurthy Iyer sir, who have extended their support for making this occasion a grand success. Once again, I welcome you all to this auspicious occasion, and all who are present here on the dais and off the dais, and we look forward to a productive and enlightening session that will undoubtedly leave a lasting impact on all of us. Thank you, and I remain.
The veterans of our noble profession are beacons whose brilliance illuminates the path ahead. The enriching experiences of these lawyers, forged through years of dedication, commitment, and hard work, serve as guiding lights that inspire all of us to strive towards excellence. Now, I call upon Advocate Roy Chacko to pay homage to legal luminary Justice T.S. Krishnamurthy Iyer, sir. Over to you, sir.
The President of this function, Honorable the Chief Justice, Justice A.J. Desai, Honorable Mr. Justice K.V. Viswanathan, Judge Supreme Court of India, Mr. K. Gopalakrishna Kurup, Advocate General, Shri Yeshwanth Shenoy, President of the Kerala High Court Advocates Association, Mr. Balaji K. Moorthy and Mr. Shankar Moorthy, sons of Justice Krishnamurthy Iyer, Mr. Anoop B. Nair, Honorable Judges past and present, family members of Justice Krishnamurthy Iyer, senior advocates, my colleagues in the legal fraternity, ladies and gentlemen. At the outset, let me express my profound gratitude to the members of the family of Justice Krishnamurthy Iyer for giving me this opportunity to pay homage to a doyen, a legal luminary, on this occasion. As we all know, Justice Krishnamurthy Iyer left an indelible mark in the legal profession. He was born in the early 20th century to an illustrious judge of the Travancore High Court, Justice K. Sankarasubba Iyer and Srimati Shankari. He was enrolled in the year 1935 in the Travancore High Court, then a princely state. He rose to eminence by dint of hard work, perseverance, and prudence. His unfailing courtesy towards the members of the bar made him a popular lawyer in the Travancore High Court. On the integration of the states of Travancore and Cochin in the year 1949, and the principal bench being located at Ernakulam, Mr. Iyer shifted his practice to Ernakulam, and soon he made a mark in the legal profession. I must say that he had an amiable disposition, he was very humble, and he was possessed with juristic acumen and forensic skill. Such is the trait of a great lawyer whom we remember today. After about few years in the legal profession, after the integration, after the formation of the Kerala state, Mr. Iyer rose among the legal profession like a wizard. He was one among the top lawyers, especially in the civil branch of law. In the year 1965, his contribution to law was recognized by the government of Kerala by appointing him as the Advocate General. Though his tenure was short, he made a mark, and as Advocate General, he added luster and glory to the office of the Advocate General as the chief legal advisor to the government. Soon thereafter, Honorable Chief Justice M.S. Menon, the longest served Chief Justice of a High Court, recommended Mr. Iyer, then Advocate General, to the bench in the year 1965. As a member of the bench, I must say that he again exhibited impeccable integrity, judicial impartiality. He was very patient to the members of the bar. And he had a very imposing personality. That is what I am told, that he was a very imposing personality. Lawyers dared not to go to his court without preparation. And that was the hallmark of a great judge. To note that his judgments were noteworthy for the precision, clarity, and brevity. One of the cases that was decided when Mr. Iyer was a judge of the High Court was a full bench decision in which Mr. Iyer was a member, and that was the contempt case against the then Chief Minister E.M.S. Namboodiripad. The majority view was that the Chief Minister was guilty of contempt. The judgment was rendered by Justice P.T. Raman Nair, and that was agreed upon by a concurring judgment by Justice Iyer. And that was upheld by the Supreme Court of India, the conviction of the Chief Minister. Maybe that was the first time in the history of the country that a Chief Minister was convicted by the High Court in a contempt matter. Thereafter, Mr. H.R. Khanna, after the retirement from the High Court, Justice Khanna, the celebrated judge, he invited Justice Iyer to be a part-time member of the Law Commission of India. As a part-time member of the Law Commission of India, he contributed to the development of law in the country. Soon thereafter, he shifted to Delhi, and he was a senior counsel. As a senior counsel, he commanded lucrative practice, especially in the civil branch of law, not only from the southern side, from almost all the states in India. They engaged in Mr. Iyer because he was known to be a master of civil law. I am told that the judge of the Supreme Court would ask Mr. Iyer if there was any clarification on a point regarding the civil law, even if he is not appearing. The judges would ask, Mr. Iyer, what is your view on this position of law? And Mr. Iyer would be quick to respond. Such was his mastery and scholarship, erudition in the field of law. After his failing health towards the 1995-96, he had to come down to Chennai, and he was with his son, Mr. Balaji. I remember my father visited him when he was in the residence of Balaji. I will be failing in my duty if I don't mention that my father and senior P.C. Chacko and late Justice Moorthy, they were the juniors of Justice Moorthy Iyer. Had it not been for the guidance and training that Mr. Iyer had given to Mr. P.C. Chacko and P. Krishnamurthy, they would not have been successful lawyers that they were. And both of them have left for their heavenly abode. My dear ladies and gentlemen, it was said by a French poet, Paul Valéry, that a great man is one who leaves others at a loss when he is gone. Certainly, Justice Krishnamurthy Iyer, who passed away, who left for his eternally reward almost a century ago, is being remembered today. And I should say, I have the pleasant duty to introduce to you a great doyen of the bar. Before I conclude, I must also say that myself and my brother Romy, who is here in the August Assembly, we had the privilege of being associated with Mr. Krishnamurthy Iyer while he was a senior counsel of the Supreme Court of India. I recall the vivid memories that we had with him. Although we spent only a few days with him, we understood as to what is Krishnamurthy Iyer. With these words, once again expressing my gratitude to the members of the family, I conclude. Thank you.
Thank you, sir. Now it is the time for felicitations. I invite Honorable Justice A.J. Desai, Chief Justice, High Court of Kerala, to render his felicitation.
Honorable Justice K.V. Viswanathan, Judge Supreme Court of India, my esteemed sister and brother judges, Shri K. Gopalakrishna Kurup, Learned Advocate General of Kerala, Shri Yeshwanth Shenoy, President Kerala High Court Advocate Association, Shri Roy Chacko, Advocate High Court of Kerala, Shri Anoop V. Nair, Secretary Kerala High Court Advocate Association, Shri Balaji K. Moorthy and Shri K. Shankar, sons of Justice Krishna Moorthy Iyer, Honorable Justice K. M. Joseph, former Judge of Supreme Court of India, former judges of this court, respected senior advocates, my dear junior lawyers, Registrar General and other registrars of this court, ladies and gentlemen. Good evening to all of you. It is with great honor and humility that I stand before you today to commemorate the memory of illustrious Justice T.S. Krishnamurthy Iyer, a stalwart of the legal fraternity and a luminary of the Kerala High Court, whose contributions extended beyond the legal sphere. Hailing from the family of judges and administrators, Justice Krishnamurthy Iyer was born on 4th June 1911 in Trivandrum. One may not wonder why Justice Iyer pursued law as his profession. His father, Justice K. Shankar Subir, served as a judge of erstwhile Travancore High Court. His younger brother, Justice A. Padmanabham, was a judge of the Madras High Court, and his nephew, Justice S. Shankarabaran, served as a judge of Kerala High Court. Besides, their great-grandfather was an esteemed administrator and civil servant who served as the Diwan of Travancore. After obtaining law degree from the Trivandrum Law College, he began his legal practice in the year 1935, firstly in the Travancore High Court in Trivandrum and later in the Kerala High Court. In recognition of his legal acumen, merit and ability, in the year 1965, Shri Iyer was appointed as the Advocate General of Kerala and worked with distinct and brought dignity and acclaim to the high offices even though his tenure was short. After a short period of service as the top law officer of the state, Justice Krishna Moorthy Iyer was elevated as an additional judge of this court on 14 September 1965. Later in 1967, Justice Iyer became a permanent judge of this court. After rendering distinguished service for more than 7 years, Justice Iyer retired from service on 4th June 1973 on attaining the age of superannuation. I am given to understand from the law journals that after his retirement, Justice Iyer donned many robes and remained active in the legal arena. He served as a member of Law Commission of India. He proved his acumen and deep intellect as senior lawyer of the Supreme Court of India and had handled complicated questions of law that demand high knowledge and industry. Justice Iyer was the chairman of Bharatiya Vidya Bhavan Kerala, an institution which has been the forefront of multifarious educational activities. I am also informed that since Justice Iyer was possessed of generous mind worth emulative, in 1997 he had donated his law library to the Kerala High Court Advocate Association, and I am sure the legal fraternity here will be ever obliged to Justice Iyer for this act of magnanimity. The life and profession of a great judge who served in various capacities can indeed serve as a powerful inspiration for future generations. Judges who have worn many robes after bringing a wealth of experience, wisdom, and perspective to their roles, enriching the legal system and leaving a profound impact on society. Justice Iyer's journey from practicing law to ascending the judicial bench reflects a commitment to justice, integrity, and the rule of law. By honoring his life and achievement, we not only pay tribute to his contributions, but also remind ourselves of the importance of impartiality, fairness, and dedication in the pursuit of justice. Justice T.S. Krishnamurthy Iyer was not merely a judge. He was a beacon of integrity, wisdom, and compassion. His commitment to upholding the rule of law and dispensing justice without fear or favor set a benchmark for the future aspirants of this profession. Throughout his tenure on the bench, he exemplified the highest standards of judicial conduct, earning the respect of admiration of his peers, colleagues, and public alike. As we recall his distinguished service to the judiciary, it is incumbent upon us to reaffirm our commitment to the ideals he stood for. In an era marked by rapid change and evolving challenges, it is imperative that we uphold the values of justice, fairness, and equality that form the bedrock of Justice T.S. Krishnamurti Iyer's jurisprudence. Moreover, Justice T.S. Krishnamurti Iyer's legacy serves as poignant reminder of the critical role that an independent judiciary plays in upholding democracy and the rule of law. His unwavering dedication to the dispensing justice without fear or favor underscores the importance of safeguarding judicial independence and preserving the integrity of our legal institutions. As we honor his memory today, let us also recommit ourselves to the pursuit of justice and advancement of rule of law. Let us strive to emulate the example set by him in our own lives and careers, ensuring that his legacy continues to inspire and guide us in the noble pursuit of justice for all. Let us remember him not for his legal acumen and judicial wisdom only, but also for his unwavering commitment to justice, fairness, and the rule of law. May his memory continue to inspire generations of jurists and serve a guiding light for all who seek to uphold the principles of justice and righteousness in our society. It is my absolute honor to share the dais with the chief guest, Honorable Justice K.V. Viswanathan, Judge Supreme Court of India, for today's event. We are truly honored to have him grace this occasion with his presence and his oration on the topic. So I will not take much time. We are eager to hear him on this topic. Thank you all.
I invite K. Gopalakrishna Kurup, Advocate General of Kerala, to offer his felicitation.
Honorable Justice K.V. Viswanathan, Judge, Supreme Court of India, Honorable Chief Justice of the High Court of Kerala, Mr. Justice Ashish Jitendra Desai, President of the function, Honorable Judges of the High Court of Kerala, Honorable Mr. Justice K.M. Joseph, former Judge of the Supreme Court, former Judges of Honorable High Court of Kerala, the President of the Kerala High Court Advocates Association, President Kerala High Court Senior Advocates Association, Senior Advocates, esteemed fellow members of the bar, family members, colleagues, friends and well-wishers of late Justice T.S. Krishnamurti Iyer, ladies and gentlemen, and all other dignitaries joining online. It is certainly a privilege for me to offer felicitations for this oration, being held in remembrance of late Justice T.S. Krishnamurti Iyer, an icon whose name will be inscribed forever in the halls of fame in the world of law. A prominent lawyer par excellence, a highly respected Advocate General who led the bar of the state from the front, an erudite judge of this honorable court, a popular mayor of the capital city of the state, a learned member of the Law Commission, and a committed educationist with consummate prudence. What more could a man accomplish in his short span on earth, and what further could be done during a lifetime? Born in erstwhile princely state of Travancore, into a household of jurists, law and advocacy was inherited by him. But in law, mere legacy will not suffice, and Justice T.S. Krishnamurti Iyer chiseled his skills in law through industry and excelled to unparalleled heights. I witnessed his incomparable legal acumen from close quarters when I instructed him in matters before the Supreme Court. Emerging areas of impact, law and the legal system, the organizers of this function have appositely zeroed on a topic which is of contemporary significance. Law, by its nature, is not static, but dynamic. Law, since its essential basic tenets, is a constantly evolving phenomenon. Such evolution in law is indispensable for assimilation of social, political and economic changes and scientific and technological advancements. The winds of change that have been brought about in every sphere of the society by way of liberalization of our fiscal structure and globalization of markets have had its effect on laws and legal system of the country. Foreign direct investments and increased international contracts and businesses demanded compliance with international treaties and conventions, and it required our commercial laws to be altered for being thus compliant. The advent in cyber world and information technology, the acknowledgement of intellectual property rights, the innovative expansions in the concept of alternative dispute resolution system, the judicial recognition of right of privacy, matters of data security, etc., have all resulted in either enactments of new legislations or rampant changes being brought about in existing legislations. The development of artificial intelligence is also destined to have an impact on the laws and legal system of our country. We, the lawyering community, being the most important stakeholders in the legal system, will be greatly affected by such changing aspects. However, we always, through our industry and constant learning, update and adapt ourselves to the ever-dynamic legal environment. I know that all are eagerly waiting to hear our guest speaker, Justice K.V. Viswanathan, a proficient orator who gives scholarly talks on multifarious topics on law. I am sure that Honorable Justice K.V. Viswanathan will capture this evening with his scintillating lecture. I once again express my wholehearted gratitude to the organizers for offering me an opportunity to speak in this occasion and also felicitate them for organizing this function. Thank you.
I invite Advocate Yeshwanth Shenoy, President, Kerala High Court Advocates Association, to render his felicitation.
Good evening. Justice K.V. Viswanathan, Judge, Supreme Court of India, Justice A.J. Desai, Chief Justice, Kerala High Court, all the dignitaries on the dais and off the dais, and my dear friends. Since we are all eagerly waiting to hear Justice Viswanathan, I would not make a long speech, but I need to tell the background of how we were able to organize this. I got a call from Justice P.B. Suresh Kumar saying that somebody wants to organize a talk. That was it. And then I get into touch with Mr. Balaji Moorthy, and somehow we have been, we have reached this stage where we have been able to have a judge from the Supreme Court to deliver this inaugural lecture. But more than as a judge of the Supreme Court, an advocate always remains an advocate, even after elevation. Some habits don't change. When we saw the topic, emerging areas that impact law and the legal system, in fact, what happened is when we decided Justice K.V. Viswanathan was going to speak, and he sought for different topics, we gave him almost 20 topics. None of them were chosen. And then Justice Viswanathan sends emerging areas that impact law and the legal system. The next thing is, I and Mr. Balaji Moorthy go and meet the Chief Justice and say, this is the program and we would like to invite you here. And then the Chief Justice looked at me and said, come on, tell me something about this topic. What is this? What is he going to talk about? Anybody who knows Advocate K.V. Viswanathan will know that he keeps his cards very close to his heart. Until he opens his mouth, we don't know what is going to come out of it. Therefore, he continues that habit even as a judge. Now, we are all eagerly waiting to hear what those emerging areas are, and taking a guess, it could be artificial intelligence. But there is something that I would like to say, just like our Advocate General said, that law is not static, law is dynamic. There would be emerging areas of law, but the most important aspect of law and justice is this: integrity, impeccable integrity. If we cannot preserve integrity in the system, whatever be the emerging laws, justice will not prevail. Therefore, it is in our interest that we have to always be vigilant and ensure that integrity is always preserved in the justice system. As Leonardo da Vinci says, nothing strengthens authority so much as silence. Therefore, I would always say vigilance doesn't mean silence. If you have to stand up, because it's always the bench reflects the bar. Therefore, we should, even before we complain about anything, we should remember that we have to step up our act and ensure that integrity remains in the system. Now I am eagerly waiting to hear Justice K.V. Viswanathan talk on emerging areas that impact law and legal systems. Thank you so much.
Thank you. Now, the most awaited pivotal moment arrives. I humbly request Honorable Justice K.V. Viswanathan, sir, to address these attentive minds who are waiting to hear your views and ideas on this topic, emerging areas that impact law and the legal system. Over to you, sir.
Chief Justice of the High Court of Kerala, Justice Ashish Jitendra Desai, Justice K.M. Joseph, my distinguished elder brother, the former colleague at the Supreme Court, distinguished judges of the High Court of Kerala, distinguished former judges of the High Court of Kerala, Shri Gopalakrishna Kurup, Learned Advocate General for Kerala, Mr. Yeshwanth Shenoy, President, Mr. Anoop Nair, Secretary, Roy Chacko, Shri Shankar Moorthy and Shri Balaji Moorthy and other family members and friends of the legal legend, late Justice TSK lyer, distinguished senior lawyers, distinguished advocates, ladies and gentlemen, a very good evening to you all. I was introduced to Justice Krishnamurthy Iyer in the late 80s, and my interaction with the distinguished jurist was between the late 80s and the mid-90s. I was very fortunate to interact with him, fortunate to have briefed him, fortunate to have attended his 82nd birthday in Delhi, fortunate to have interacted with him in the library. But little did I realize that 30, 35 years down the line, I'll be standing before you to deliver the inaugural Memorial Oration. I deem it a great privilege, and I thank the family members for bestowing this honor. As you are aware and you have been told, he was a prominent lawyer, a respected advocate general, an extraordinary judge, a worthy member of the Law Commission, and a much sought after senior lawyer in the Supreme Court. But above all, he was a noble human being. The following incident, which I happened to read from the speech of Sri Abraham Vakkanal, the then president of the Kerala High Court Advocates Association, at the reference organized on the 6th of September, bears testimony to that virtue. One incident involving Justice Krishnamurthy Iyer I recently learned from our senior lawyer, Shri P.C. Chacko, who now returned after a bypass surgery. And to cut it short, the incident was that Justice Krishnamurthy Iyer was himself convalescing in another hospital. While he was being admitted there, on a wheelchair, went and called on Mr. P.C. Chacko, who was recovering in another hospital. That was the love and affection he had for his juniors, and that brings out the humanness of the man. But before we really get to the topic, for all these attributes, should not be forgotten that Justice Krishnamurthy Iyer had a tremendous sense of humor. And I was at the receiving end. We were on the bus to reach the aircraft, which on that particular day was parked far away. We were both going to Chennai. Justice Krishnamurthy Iyer was seated and I was standing. And as the bus was meandering, it was meandering for very long, and I could see him, feeling a little restless. And he looked at me and asked me, Viswanathan, is this bus taking us directly to Chennai, or are we only going to the aircraft? Those are fond memories I have of him. And it's only a fitting tribute that the late Krishnamurti Iyer family have organized a memorial oration, because he was truly a legal legend, and this is the right way to perpetuate his memory. Now, coming to the topic, let me break the suspense which Yeshwanth has created. A lot of topics were debated. Nothing was rejected out of hand. The first default option was to go to constitutional law, which is the first love of most of us. But midway somewhere, the Chief Justice of India deputed me to attend a roundtable conference organized by the Supreme Court of Singapore and the Durham Law School, with Chief Justice also giving his inputs on the topic, our Chief Justice. And I found that the topics discussed there were of primordial significance. And I thought that the purpose of deputing someone to attend a conference is so that somewhere down the line he comes back and is able to share with with his friends and the legal fraternity the cutting-edge topics and the legal dimensions that they have. So that is what has resulted in the choice of the topic. And if you see the topic carefully, it is emerging areas impacting the law and the legal system. Like, law always reflects what goes on in the society. So there are things happening around which have serious legal implications. So I thought I'll identify 4 of them. And what I have chosen to talk to you, not so much as to, give a dissertation thereof, but to flag certain ideas so that your ideas get liberated, your mind gets liberated, and you pursue that as part of, your interest. Some of you must already be pursuing it. So the topics are climate change. Climate change is not necessarily what goes on in the atmosphere. Of course, it begins with that. But there are legal dimensions to climate change. And as members of the legal fraternity, we must do our bit. We must be aware of it, and we must do our bit to mitigate what is going on. We will see what are the legal issues that may arise on climate change. The second aspect is, I think, very important. We are all victims of it. Disinformation. There's a lot of disinformation going around. Some call it the truth decay. How do you check this? With this media explosion, on the one hand, you have the guaranteed right of free speech, and it is completely a non-negotiable right, subject only to the reasonable restrictions. But today, what has happened with the explosion in the digital era is that deliberate disinformation of all kinds has a serious impact on the rule of law. So within the parameters of the Constitution, what could be the methods of regulating it, checking it, without in any manner compromising on free speech? Are there any methods adopted? Have democratic countries resorted to any measure? If so, is it worth replicating here? As a judge, I do have my restrictions, but there will not be any restriction in placing before you what the scenario is, so that we assimilate and adopt, because there can never be two opinions, that it has to be checked. But the first problem is who checks and who identifies what is truth and what is falsehood. So these are areas which we must think on. So I thought I would share with you because it has a dimension of constitutional law. The third aspect is, of course, artificial intelligence, which was mentioned, and I think it is something which we must deeply ponder on. We must examine what the legal questions that may arise, if artificial intelligence is, integrated. There's no two opinion that it has to be integrated. It can't be a substitute. You will have to partner AI, but there are some legal aspects which will arise. What could be the regulatory mechanism? What should the regulatory mechanism provide? And lastly, of course, you mentioned data protection and privacy, because world over litigations are emerging, and so we will see a few of them. I thought this will be a fitting tribute because Justice Krishnamurthy Iyer always pushed himself. He was a senior advocate, he was an advocate general, he then moved on to become a judge. He then was invited by no less a person than Justice H.R. Khanna to be in the Law Commission. Then was a successful senior advocate arguing myriad areas of law. So it is in that spirit that this topic has been chosen, and we will see how we get there. Climate change, you all know, it's not a distant phenomenon. It is happening here and now. For the uninitiated, when we burn fuel, they release greenhouse gases, especially carbon dioxide. These gases act like a blanket around the Earth, trapping the sun's heat and causing our planet to warm. That's the theoretical part of it. It is an existential threat. But where do you locate the interrelationship between the state and the citizens in this? You have the binding international conventions. I'm not going to labor them. They are available for you for easy reading. The United Nations Framework Convention on Climate Change and the Paris Agreement, where every country, including India, has its commitments. We have a commitment to achieve approximately 50% cumulative electric power installed capacity from non-fossil fuel-based energy sources by 2030, with support from the transfer of technology and low-cost international finance and X, Y, and Z. Fortunately, the Supreme Court has stepped in, speaking through the Chief Justice in the Ranjit Singh case. And he holds, and the court holds, that citizens, persons, do have a right to be free from the adverse effects of climate change. It's held the inability of underserved communities to adapt to climate change or cope with its effects violates the right to life as well as the right to equality. This is better understood with the help of an example. If climate change and environmental degradation lead to acute food and water shortages in a particular area, poorer communities will suffer more than richer ones. The right to equality would undoubtedly be impacted in each of these instances. This was in the context of, preserving the great Indian bustard and the pelican, which were birds which were getting extinct. And not to compromise with the non-renewable energy. People, who were producing power by the non-renewable source of energy without resort to fossil fuels were given certain directives by the Supreme Court in an earlier order. So evolving the principle of environment versus conservation, and not merely environment versus development, this right was evolved by the court. But then, when you enforce these rights, when you take a party to court, the first problem leading jurists say is the problem of causation. How do you locate, where do you establish the causal link, the causans? Do we go for the traditional but-for test, which we normally resort to in any litigation in tort, that but for this, the third thing would not have happened? Is but-for test the relevant test? And if you are jettisoning the but-for test on causation, why do you say that? These are questions which are bound to arise, and it's time that we also ponder over it. The standard test for causation in tort is the but-for test. That is, can the claimant prove that the alleged damage would not have occurred but for the defendant's acts or omissions. Where a rigid application, this is my comment, of the but-for test is inconsistent with these objectives, that is, can the claimant show that damage would not have occurred but for man-made climate change? Or if so, can they show that the relevant degree of climate change would not have occurred but for the action and omissions of the defendant? Courts around the world are adopting a more flexible approach. In circumstances of scientific complexity, for example, or where multiple causes are present, courts have adopted alternative tests, such as whether a defendant's act or omissions made a material contribution to the harm or materially increased the risk of the harm occurring. More specifically, in the context of pollution from different sources, they have developed the commingled product theory. Suppose multiple people are responsible for degeneration of a pollution. There's an apportionment of liability, and there's a theory of commingled product theory which is being evolved, which is being borrowed into this aspect. So as lawyers, it's our responsibility as members of the legal fraternity that these principles adapt, as was rightly mentioned by the learned Advocate General, with the progress of times, so that we are not caught up in the old theories which are unable to address the current societal problems. Former Chief Justice James Alsop of the Australian Federal Court, who had presented a very distinguished paper there, referring to the issue of establishing causation, states, not to alleviate the requirements of but-for proof in such circumstances might reveal the law was unable to adjust to the realities of life and was unable to give effective and just remedies. And there are instances on the case of the asbestos, victims, the victims of the mesothelioma disease from England, and they borrow this principle and cross-pollinate them. Justice Sikri, who also presented a paper, referred to the Grantham Research Institute on Climate Change. And this is only to tell you how the litigation on climate change is increasing, manifold. Finding more than 1,000 climate-related cases have been filed since 2015, in comparison to about 800 cases filed between 1986 and 2014. And unlike in the past when climate change cases were generally unsuccessful, the trend now appears to be changing. According to the Grantham report, in nearly 370 decided cases, outcomes favored climate change action in 58%, were unfavorable in 32%, and had no clear impact in 10%. How have the courts in other jurisdictions enforced national commitments under the Paris Agreement? Netherlands has taken the lead in a case called the Argenda Foundation. When citizens moved the court, the case is of course pending in the highest court there, the judgment of the Dutch government, when Dutch government had acted unlawfully in taking insufficient action towards the UN goal of keeping global temperature increases within 2 degrees Celsius of pre-industrial conditions, the courts were moved and the state was ordered to immediately reduce its greenhouse emissions to 25% by 2020 in accordance with its human rights obligations. So here is where you find that courts are evolving certain positive obligations in the state. Hitherto, not that positive obligation is something which we are unaware of. We did it in the telephone tapping case, we did it in the sexual harassment at workplace case before the legislations came in. But this is what is happening now internationally with the treaty, obligations as the basis. I'm not saying that the same view will be taken. Of course, our courts will have its own analysis, but this is the way the climate change aspects have been impacting the legal community. And that is why I thought it would be important to highlight that aspect to you. Senior women citizens moved the Swiss court for failing to enact to combat climate change legislations and to reduce carbon emissions, and appropriate directions have been given by the Switzerland court. So these are some things which we should be aware of. I've already dealt with about the aspects of hauling up private companies who emit the carbon emissions to restrain them and to bring them within the limits. In New Zealand, in a case called Smith versus Pontera, Michael Smith, a Maori leader, sued New Zealand's 7 largest greenhouse gas emitters, collectively responsible for 1/3 of the country's emissions. It was argued that these companies, their activities amounted to tort of public nuisance and negligence, and therefore sought a novel claim for a climate change damage duty. The Supreme Court of New Zealand, overturning the Court of Appeal, proceeded to emphasize that that was, of course, a striking off action like our Order 7, Rule 11, that to strike off motions in novel climate change classes, the activities contributing to climate change can potentially qualify as public nuisance, even if they are not illegal under the existing statutes. And the ruling was against the striking off action, and they said this should go to trial as it involves tribal issues. Then you have cases in Australia where ministers have been hauled up for want of duty of care. There, of course, they have taken a restrained view, holding that there is no direct linkage. But the law is pushing itself. The frontiers are being pushed, and it's only fair that to conclude this aspect, we state that there's an international scientific consensus that human activity has resulted in climate crisis that we face today. In humankind's endeavor to create a sustainable planet for ourselves and for our future generations, there will undoubtedly be crucial legal challenges to iron out in the near future. The increasing number of cases resulting to climate change being filed around the world demonstrates the growing importance of this subject as an emerging area in law. There's a growing body of jurisprudence on this subject in relation to matters like locus standi, causation, and justiciability. Therefore, as lawyers, it's incumbent that we understand these possible issues and equip ourselves to deal with the same. We go to a little more interesting aspect, hopefully, of disinformation. The disinformation is something which we are all subjected to. This morning, or maybe half an hour back, you would have received on your WhatsApp certain startling facts. And there are people who believe and proceed on that basis. I don't know whether in a solemn occasion like this I should share a quip. Today they say the definition of a straightforward person has changed. Straightforward person is one who, without reading, immediately forwards a WhatsApp message, not the straightforward person that we think of. But jokes apart, we stand at a critical juncture in the digital age that is characterized by an explosion of information and the emergence of non-traditional sources such as X, formerly Twitter, Facebook, WhatsApp, and YouTube, all capable of transmitting and receiving information at breakneck speed. See, the traditional sources that pervade and disseminated information, first the newspapers, and then the official television, then the private television, are now giving way to the digital media. It has its advantages, but it has its disadvantages. But how do you legally regulate them? That's what we'll examine briefly. With this increased access to various forms of information, states and the legal system find themselves in a quandary as the spread of particular kind of information known as disinformation rises across platforms. It can seriously impact rule of law, apart from impacting other matters. The only question is, who should stop it? How do we stop it? What are the measures that we can resort to it? And the sooner we think on these lines, I think it will forestall a lot of problems. It forces a lot of issues that I can, imagine. In fact, the World Economic Forum's report on global risks published in 2024 identified disinformation to be emerging as the most severe global risk anticipated over the next 2 years. And there are other commissions, but the best treatise on this is by a gentleman called Lee McIntyre, who's written a book on disinformation. And he identifies 3 categories of persons involved who are protagonists in the drama. The person who creates the disinformation, who just, the click of a button spreads it. The person who amplifies the content, the intermediaries and others, and the person who believes the information, the gullible, person who believes it. It's disinformation across the board. Now, without a person who tends to believe a content which is disinformation, there would be no impact created by any content that is created and then amplified. But then, how does it affect the society? This is not purely legal, but this is what the impact that it will have on the society. Any democracy mandates us even to consider that we agree with, while also engaging civilly with any disinformation we agree with. There is no conversation happening here. It is one-sided. You are given the information, and people get polarized on that basis. People tend to believe it, depending on, what they want to do with it. People don't check it. And this information is widely circulated. Opinions are formed. Actions are taken based on that. But I foresee a graver problem. Slowly and steadily as we progress, when people realize after a few years that the information was false and that it was a false information which was the basis of a decision taken by them, not once, not twice, but on several occasions, a trust deficit will set in among all of us. So much so that it is bound to impact our normal conversations. While today, the default rule in conversation is that you believe, unless proved otherwise. Slowly and steadily, I foresee a trust deficit setting in. And that is not a happy scenario, because you would proceed on the basis that the information is false over a large period of years after you have been victim of it. But still, we haven't come to the problem of how to tackle it. And thirdly, it, of course, the effect that spread of information has on the formerly reputable sources of information. All of us would remember a time when nobody would even question a certain piece of information appearing in our print media. However, in the digital era, people are no more able to figure out where the news is actually coming from, and there is an increasing struggle to separate fact from fiction. But where is the tension? Where is the tussle? The tussle is the amplifiers, the originators also have the right of free speech. And our courts have, interpreting 19.1 and 19.2, been very clear that unless it falls within one of those 8 reasonable restrictions, and unless it tantamounts to incitement to violence, mere advocacy would not be proscribed. We have followed Brandenburg versus Ohio. Shreya Singhal has reiterated it recently. The point that I want to make is not that you compromise on free speech, because that will have its own deleterious effect. But alongside guaranteeing free speech, how do you check this malaise, which is fast gripping us? In this backdrop, the following are the potential pressure areas that are the subject matter of discussion around the world, which will arise when any measure is devised to try and control the spread of disinformation. Firstly, the line between censorship and misinformation control can be blurred. While it is crucial to remove harmful content, there is a risk that legitimate discourse and diverse opinion might be suppressed. We must be vigilant against overreach that stifles dissent or controversial viewpoints. Secondly, determining what constitutes disinformation can be subjective. Different groups may have conflicting views on what is true and what is false, and even authoritative sources may not always agree. This complexity makes the task even more challenging. Thirdly, the role of social media and tech companies is pivotal. These platforms are at the forefront of moderating content and face immense pressure to remove harmful information while upholding free speech. Their policies and algorithms can inadvertently promote or suppress certain viewpoints, adding another layer of complexity. Fourthly, the legal and ethical limits of controlling disinformation are constantly evolving. Governments and international bodies grapple with setting legal boundaries. While laws against hate speech, incitement to violence, and defamation exist, extending these to cover disinformation is controversial and is difficult to enforce uniformly. As far as we are concerned, we of course have the IPC and the Information Technology Act and the recently formulated IT rules. I don't want to labor them because there is one pending litigation on the fact check aspect, which on the disinformation on certain governmental aspects. We'll leave that aside. We will see how at least two countries, Singapore and Germany, have approached this. Singapore has a legislation called the Protection from Online Falsehoods and Manipulation Act. Now, the remedy suggested is very simple, but there are some problems in the mechanism which perhaps can be ironed out if we put our heads together. They have a mechanism where if a certain information thought to be false or tantamounting to disinformation is aired, they have an authority now vested in the government who have a power to direct that medium to publish alongside the false information the correct information. The logic is answer to free speech is more speech. There is a theory that instead of suppressing free speech, you must have more speech. And I've always wondered, just an aside, that apart from handling hate speech by law, why cannot it be done by harmony speech? Why cannot Good Samaritans? The law can take its own course. That is clearly incitement to violence. That should be curbed. But I think if answer to free speech is more speech, the answer to hate speech, apart from a legal sanction, should also be harmony speech. But the problem with the Singapore legislation is that it vests the adjudicating power in the governmental machinery. And that may not be entirely acceptable. But if there is to be an independent body which will regulate it, at least it may be a starting point to address this problem, that alongside false information, you have the correct information which is mandatorily carried. The German model is grounded on self-regulation. It's always been felt that the best way to regulate free speech is to self-regulate. You have the bodies, the Press Council of India, you have similarly for the television channels, they self-regulate, but they have an interesting mechanism. They have a time limit before which you must self-regulate. They have an authority in-house who will self-regulate. But if it doesn't do that, then, a certain sanction kicks in. Maybe after 5-6 opportunities, a sanction kicks in by law. That since you have not self-regulated, we are now going to take it upon the law to sanction you a penalty. I think it is a model worth pursuing because the proponents of free speech, the champions of free speech, and all of us are champions of free speech. We don't want to compromise that. Need to address this problem and to come out with measures. So maybe, somewhere down the line, a hybrid model which assimilates both these models could be thought of, but it is an immediate desideratum that we check this, but mere law is not going to help you. On an individual level, it is important to recognize that education and digital media literacy in tackling the issue of disinformation is also important. The real solution to disinformation, rather than from the law, comes from the changes that each of us can make to our everyday lives. Apart from educating people about digital media and how information is created and amplified, some steps identified by Lee McIntyre are: confront those who spread disinformation, resist consolidation of opinion, and tune out misleading information, but all within the framework of law. And to conclude, in the foreseeable future, we are going to see an increase in measures attempting to discover and counteract disinformation. As members of the legal community, we are going to be uniquely placed right at the forefront of various kinds of legal battles that will arise out of these measures. A, judicial review of the laws seeking to restrict freedom of speech. B, legality of take-down measures, when an intermediary is asked to take down a certain offending post. Petitions seeking directions to take down harmful and false content, to name a few. It is for these battles that we need to equip ourselves with the views and experiences from around the world who are facing similar troubles and where the laws are mostly in the incubatory phase. While the right to express ideas freely is a cornerstone of our democratic values, disinformation threatens to erode the very foundation upon which those values are built. It is imperative for us as legal professionals to advocate for measures that safeguard the truth without stifling legitimate expression. By fostering a legal framework that promotes media literacy, encourages responsible discourse, and holds purveyors of falsehoods accountable, we can uphold the integrity of both free speech and the rule of law. I hope that this talk initiates a conversation and, sets you thinking, liberates a few minds, and some of you come out with brilliant ideas to counter this within the framework of our Constitution. With this, we move on to artificial intelligence. Today's day and age, you cannot not speak of artificial intelligence, though I have a problem with the phrase artificial in it. Having read a bit of it, I feel that it is certainly not artificial. You could have some other acceptable phrase for it, because the phrase artificial intelligence dissuades people from adapting and adopting artificial intelligence, even if it is not to substitute the normal functioning. The other problem is, when you speak of artificial intelligence, there's the tendency to believe that it will substitute humans. No. At least for the administration of justice, one can say with a certain amount of conviction that partnering artificial intelligence will only uphold the rule of law, and it will not negate the rule of law, provided it is, the artificial intelligence is meaningfully and responsibly employed. That is going to be the approach. Now, how does it impact our legal system? What is happening around the world? The Vidhi Center for Legal Policy had a paper on responsible AI for the Indian justice system, and they refer to certain tools adopted by countries abroad. Socrates, an artificial intelligence tool used by the Brazil's Supreme Tribunal of Justice, the country's highest appellate court, examines appeals and recommends a decision based on the impugned judgment. Now, I am not advocating this straight away. In fact, at a recent conference, the promoters of the artificial intelligence tool, Harvey, told us that they were commissioned to do one particular work, that is, to predict how many questions justice Gorsuch of the United States Supreme Court would ask, and what would be the questions in a particular case which was coming up for arguments a few months down the line. And they tell us that 10 out of 11 questions predicted were asked by Justice Gorsuch. So I was only telling them that if Justice Gorsuch comes to know of this, he will first check what are the likely questions that he will ask and avoid asking those questions. We don't have to substitute artificial intelligence. Brazil also uses another tool called Victor to conduct preliminary case analysis and filter out frivolous matters that only serve to increase the burden. Now, even if we employ this, there will have to be a human oversight over it. When we come to the regulating part of the AI, we'll discuss briefly, because there can't be a full-fledged discussion here. Singapore has had a tie-up with Harvey, but now, in the last 6 months, but they have iLab, chatbot identifiers, uses legal issues and offers them relevant information as guidance. It also determines a person's eligibility for legal aid and directs them to legal professionals who may assist them. Another important use is for the party in person. Today you have rambling pleadings by them. You don't blame them. But it appears AI can help them draft intelligently. And in that way, not to eliminate lawyers, but for those of them who anyway choose to appear in person, to make an intelligent pleading for the court. Artificial intelligence continues to evolve its impact in increasing fields. It's already impacting healthcare. I read in Kissinger's book that the Massachusetts Medical Institute found out and the antibiotic halicin only because of the AI research. Otherwise, it appears it would have taken years together and enormous amount of money with no certainty. And this antibiotic was identified so that it could directly go and, attack the infected area. It's called halicin and it's a product of AI. If developed and deployed responsibly, AI can improve the administration of justice while saving time, resources, and minimizing human error. Now, I don't want to labor in Kerala particularly about the benefits, because Kerala has already pioneered. The High Court has pioneered, the subordinate judiciary has pioneered, and it's only proper to mention here as a tribute to Justice Krishnamurthy Iyer in his Karma Bhumi, the High Court, that the Kerala judiciary has been at the forefront of adopting technology, particularly AI-based tools. Like other high courts, Kerala High Court is also using AI tools in the justice delivery system. It was recently in the news that the Kerala High Court and district courts have successfully used Anuvadini, an artificial intelligence tool, to translate judgments of courts to Malayalam. How beautiful a name, you see. When you say Anuvadini, you immediately want to accept artificial intelligence. As of July 2023, using this tool, more than 317 High Court judgments and over 5,136 District Court judgments have been translated from English to Malayalam and uploaded on websites of the respective courts. It was also learned that there is a proposal to share translated versions of judgments with the Legal Service Authority for imparting legal education. The idea is ultimately we are for the common man, the consumer of justice. We have to speak and deliver in the language known to him, but English is the accepted language because it is acted as a link language. I'm not saying one way or the other. But today we have these tools which will translate and reach him, at his doorstep for him to fully comprehend what has happened to his case. The Supreme Court has taken tremendous initiatives, and Chief Justice Chandrachud has been at the forefront of pioneering stellar measures. The natural language processing power to transcribe court proceedings. Today you will find the Constitutional Bench proceedings are transcribed as it is. The advent of AI transcription, at the close of the day, the judge will have access to the transcript. Even while reserving a judgment and you want to dictate it, you want a clarification, you could go back and read or play the tapes also. Now, as far as the administrative part is concerned, it is already in vogue. the Supreme Court has a measure now scheme to put it in the registry so that the office objections are identified, and it will help in those matters also. But speaking of AI, we can't not mention the possible drawbacks that AI also brings, so that when we go to the part of regulating it and providing a governance model, we address this aspect also. In the legal field, the use of AI can have profound consequences on the restriction of persons' life and liberty, particularly if used by criminal courts to detain and sentence, and by law enforcement to identify and arrest criminal behavior. And there is a concrete example. In 2016, a trial court in the US, a case regularly discussed upon, but I'll be failing in my duty if I don't mention it, decided to sentence a man to 6 years in case related to a drive-by shooting while relying on predictions obtained from Compass, called the Correctional Offender Management Profiling for Alternative Sanctions, an AI tool. Now look what happened. Loomis, the convict, challenged this before the Wisconsin Supreme Court, citing the non-transparent black box-like nature of Compass. However, in this particular case, the use of Compass by the trial court was upheld by the Wisconsin Supreme Court for the reason only that it was not the only basis for the trial court's decision. It referred to it, but not relied on solely, and the conclusion was otherwise justifiable, even if this was eschewed. Nonetheless, the discussion generated by this case are important in that they point to the dangers that come with the use of AI technology. Now, what should be the governance model? We, of course, examined a few in the different sectors, and this, without a governance model, we don't know whether a legislation is the remedy or it could be by a policy. First of all, there should be legal compliances. It should respect the existing laws, regulation, particularly the data protection laws. And there should be accountability. Now, when we say accountability, Lord Hodge, the Deputy President of the Supreme Court of the United Kingdom, that is when he wrote it in July 2023, in his lecture, The Law and AI, a very fascinating article, it is available on the UK Supreme Court website. Those of you interested could refer to it. He says that the following legal questions would arise. Will there have to be legislation to impose liability on the developer of the artificial intelligence system, as one might in relation to the manufacturer of a driverless car? Or should the legislation impose liability on those who choose to use such devices, that is, the operators? Whom will the accountability lie in case there is, a mishap? Or is it fair to hold humans liable at all if the AI systems write their own algorithms? Because beyond a point, today's machine is not like a calculator. Today it arrives at its own decisions by a process unknown. Nobody is able to fathom what's going on inside. To address such issues, we need a governance framework to set the accountability aspect intact. There has to be, like the guidelines provide, it is footnoted, fairness and bias mitigation, data quality and security, and of course, human oversight. Not that you do everything that AI does, but at a point where you need to check. For example, in a case with bulky documents and facts, it was suggested in a conference, I don't know whether it can be implemented. The UK, at least the Court of Appeal has this practice. Once the draft judgment is ready, it is given to the lawyers to verify before it is pronounced. And I remember an issue having arisen of one such draft judgment getting leaked. But keep that aside. Suppose if a case summary is made, and if it is given to both the legal teams to tell us, is there any inaccuracy, and if so, what, to justify it by an affidavit. Would it be too much? Would that not aid the process in today's day and age? Would it not further the rule of law? That in terms of time, with so many cases pending, that we partner AI, we keep the human oversight, and we devise mechanism to, see that AI helps us in the process. Because our problem is pendency, and I personally feel that AI can be responsibly and intelligently partnered. That could be, in the absence of any other solution that we think of, could be a solution to seriously address the pendency problem. Apart from the routine pattern cases of motor accidents, land acquisition compensation, going into, the AI mode of resolution with the human oversight. We'll do it carefully, but we need to seriously think of it. Continuous monitoring, stakeholders' engagement, and there have been cases which have arisen. Somebody wanted a patent. After disclosing that I didn't invent it, it is the machine which invented it, and court said no in England in Taylor's case. Somebody sued Air Canada, saying that the chatbot interface said, I give you a discounted fare if you are a bereavement traveler. They have a scheme where if you are traveling on account of the death of somebody, you could say you are a bereavement traveler. And then that was misleading. He couldn't get the benefit. He went to court and he relied on the chatbot advice and claimed $880, a person called Moffat, who sued Air Canada. And Air Canada argued that the chatbot is a separate legal entity. However, the court held that Air Canada is responsible for all information, including that generated by chatbot. Because if you promise something on a chatbot that you have a bereavement discount, you jolly well give it. Now, but most important aspect of AI, which has to be, widely discussed, is continuing legal education for us and redrafting the syllabi in the law schools. Because without that, it is going to be difficult. It may be easier for the newer generation because it's easier for them to assimilate technology in the legal syllabi. But for those of us who are already in the thick of things, fast approaching the sell-by date, we need to have a system of continuing education. So the recommendation is the best defense against AI's rising power is a continuing education about it to ensure that judges, lawyers, and the administration of justice benefit from the advantages that AI brings. An ongoing program of digital and technological literacy is paramount. Specialized training programs and workshops can educate legal professionals about AI tools, their application, and the ethical issues surrounding their use. All stakeholders in the legal ecosystem, from law schools, firms, individual practitioners, and bar associations to judges and court staff, must participate. Academic institution and industry expert must be consulted in the design and teaching of such program. Very important for such programs to be made accessible to all. I think this is important. Without this, we will lag behind. So ultimately, the conclusion is AI is not a disruptor if intelligently employed. And with that, we are on the home bend now, as they say in racing parlance, on data protection and privacy. Not that new and emerging area, but since the AG also mentioned it, initially privacy was thought of as, Lord Coke defined it as every house is a castle, and I think, and as well for its defense against injury. But today, the Supreme Court has stepped in. You have various kinds of privacy. I'm not going to carry coal to Newcastle, or since Justice Matthew is here, to employ a phrase, Justice Joseph is here, to employ a favorite phrase of Justice Matthew, to do an idle parade of familiar learning, a particularly favorite passage of mine. Eric Bloom, Professor Emeritus at Copenhagen, says, privacy does not merely concern the physical life of the individual. It's also related to the immaterial life of the individual. In this sense, privacy provides some kind of protection of the ideas and information that is related to the individual person. Individual may not own this information in the same way as he owns his house, but the integrity of the person may be violated when others use information about him. So today the emphasis of the talk will be on informational privacy, one of the privacy identified by the Supreme Court. And that leads to, the privacy principles of which you are familiar, because there is litigation which is arising on this. On notice, on the choice and consent, on the collection limitation. You need to know, you need to collect only on a need-to-know basis. If you breach that, you could be violating the privacy. The purpose limitation, also the purpose for which you are collecting. All this, the aggregators are already, being taken to court. Uber is taken, and in 2 Italian cases, the food providers have been, suppliers have been taken to court, asking for data of the employees. And there a question has arisen in the process of furnishing you data of the passenger, of the driver, their working hours and their conduct. What happens if the data of passengers are also involved? Can they be redacted? These are questions which are bound to arise. They will arise here very soon because we already had the Data Protection Act. And of course, correction, access and correction, people say there is a right to be forgotten today. That I can go to court and have my, identity removed. Suppose I've been wrongly involved in a criminal case, and that ends in an acquittal. I don't want that data or that information to stay there. And about disclosure, openness, and accountability, these are all well established. There's only one interesting case I'll refer to and then conclude. You see, all of us, when we operate our computer, we gleefully, accept those cookies. And those cookies leave a trail behind. They leave a lot of information about the aspect that you're looking for, that the subject that you're interested in. If you're looking at some drugs, if you may have an ailment, you'll suddenly get a mail in your email, for diabetes, or for a WhatsApp saying for the heart ailment. How does it happen? There's targeted advertisement happening. There's data getting collected, and a full-page advertisement in a newspaper would cost you a bomb. But you could have, for a very economical price, a targeted ad. 4 square kilometers around Supreme Court or Kerala High Court, lawyers, law books, and it will reach. To that extent, that is why data, they say, is today's oil. But this Vidal Hall versus Google was a case where the claimants complained about what became known as the Safari workaround. The essence of the complaint is that Google collected private information about the claimant's internet usage via the Apple Safari browser without the claimant's knowledge and consent by using a small string of text saved on the user's device called cookies, not biscuits. This allowed Google to recognize the browser sending the browser-generated information. The BGI was then aggregated and used by Google as part of its commercial offering to advertisers via its double-click advertising service. This meant advertisers could select advertisements targeted or tailored to the claimant's interest, as deduced from the collected BGI, the browser-generated information, which could be and were displayed on the screens of the claimant's computer devices. This revealed private information about the claimants, which was or might have been by third parties. And of course, they were taken to court for violation of the UK Data Protection Act. Again, in UK, like here, you have this striking off action, but the court held that the misuse of private information should be categorized as a tort for the purpose of service outside jurisdiction. That was a service issue, and misuse of private information is a civil wrong, and the matter is pending trial. Now, I refer to the cases which came up for discussion in the conference there about the food aggregators and the cab aggregators. There's a lot of data going in. Time you book, your name, your phone number, the driver's name. Now, suppose Uber wanted to penalize drivers, and they say that we have perused your record for the last 6-7 years. Now, questions have arisen on storage limitation. Can you save this data for such a long period? How long is too much? When you ask for data, as I said earlier, the passenger's information, unwittingly being passed on, do you have a right to redact them and deny them? No, these are issues which will arise on those privacy principles. The hardcore application cases, the privacy is sorted out now. The Act is in position. This is the kind of litigation that would be generated. So with that, I think it's time to draw curtains on today's oration. Considering the time constraints, what could be discussed are only the highlights with an intention to flag these issues for you to probe them further. Each of these, I feel, are crucial and vital and could be the subject of separate discussion themselves. There's no doubt that each of these emerging areas impact law and the legal system in myriad ways, and it is time that the legal community is conscious and takes adequate steps to equip and handle. That was the spirit in which this topic was chosen. I only hope that you found them interesting as I found them to be. And I once again thank the family, I think, for a legal legend. The right way to perpetuate memory is by organizing, topics and seminars of legal discussion. Thank you very much for your time this evening, and thank you for the opportunity. Thank you very much.
Thank you, sir, for your thought-provoking insight on new terrains of law that impact the legal system. Thank you, sir, for inspiring us to break open the doors of emerging areas of law and create new opportunities for us in this profession. The answer to hate speech should be harmony speech is essentially a statement that acquires great relevance. Thank you, sir, for leaving us with that evocative thought for this wonderful evening. Thank you so much. Now, I call upon Balaji K. Moorthy, sir, son of T.S. Krishnamurti Iyer, sir, to render his vote of thanks.
Chief guest of this evening, Honorable Justice K.V. Viswanathan, Chief Justice of the High Court of Kerala, Honorable Justice Ashish Jitendra Desai, Honorable Judges of the High Court of Kerala, former Judge, Distinguished Judge of the Supreme Court of India, Honorable Justice K.M. Joseph, former Judges of the High Court of Kerala, respected Advocate General Shri Gopalakrishna Kurup, respected President of the Kerala High Court Advocates Association, Shri Yeshwanth Shenoy, respected Secretary of the Kerala High Court Advocates Association, Shri Anoop Nair, distinguished senior advocates, and members of the legal fraternity, respected lawyer Roy Chacko, members of the press, friends and well-wishers, and my dear family members. I stand before you as a representative of the Justice TSK family. We dearly miss two of our siblings. I take this opportunity to pay a homage not only to them, but to our dear uncle, late Justice S. Padmanabhan, a former judge of the Madras High Court, and our dear cousin brother, late Justice S. Shankar Subban, a former judge of this very High Court. It may not also be out of place to mention the name of Sri P.G. Thambi, who was erstwhile the Director General of Prosecution, who right in the early 2000s worked earnestly with me to get this oration going. I am sure they are blessing this evening's proceedings from their heavenly abode, along with our parents. Honorable Justice K.V. Viswanathan, on behalf of all of us present here, I wish to place on record our sincere thanks and gratitude to you for delivering this inaugural Justice T.S. Krishnamurti Iyer Memorial Oration. Sir, what you have done today is to turn into reality a 25-year-old dream of our family and well-wishers. We shall always cherish with great fondness your simplicity, your sincerity, your humane touch, and above all, your kindness in not only agreeing to deliver this oration, but in every single interaction of yours with me. Sir, may I request on behalf of the family and all of us present here to kindly accept a memento as a token of our love and affection, a memento which is nothing but a shawl. And Mr. Shankar, can you please wait? Thank you. A shawl and a memento and a book. I request Justice TSK's son, K. Shankar, to kindly do the honors. Shankar is a big doyen in the Indian and international maritime industry. Thank you, sir. Honorable Justice Ashish Jitendra Desai. Sir, Kerala will always remember you for your contribution, not only to this High Court, but to this state. The first ever time I entered the chambers of a judge was your chambers, sir. I entered with a lot of trepidation, and I must confess that I was a complete nervous wreck. But you put me at ease immediately, with your gentle and calm demeanor. So we thank you very much for so graciously agreeing to preside over this oration. May I request Justice TSK's granddaughter, Uma Suryanarayan Mishra, recently retired as a Joint Secretary, Cabinet Secretariat of the Government of India, to kindly do the honors. Honorable judges of the High Court of Kerala, you've all been so kind to find the time to be present here despite your very busy schedules. We thank each and every one of you for honoring us with your presence. Respected and distinguished former Judge of the Supreme Court of India, Sri K. M. Joseph, as well as former judges of the High Court of Kerala, words fail me to express my sincere thanks and gratitude to each and every one of you for being here with us. Your mere presence has added so much of honor and splendor to this evening. Respected Advocate General, Sri Gopalakrishna Kurup, the moment I met you, I became your fan. You have been very patient with me. Your gentle and disarming smile, your simplicity and modesty, and your encouragement is what has contributed to a large extent to the success of this evening. Sir, really, we thank you very much for all the support. May I request Justice TSK's granddaughter, Anupama Gopal, a marketing guru and a fitness expert, to kindly do the honors. Respected Shri Yeshwanth Shenoy, the President of the Kerala High Court Advocates Association, the word not possible, I don't think even exists in your dictionary. Right from day one, over the past many months, You have so patiently tolerated my innumerable phone calls and messages, not once showing your discomfort or impatience. You have walked with me every single step of the way. This evening would definitely not have been possible without your unstinted support and the support of your dynamic committee members. Shri Yeshwanth, Shenoy, we thank you very much from the bottom of our hearts. May I request Justice TSK's grandson, Krishna Balaji Moorthy, a distinguished lawyer from the Bombay High Court, and a partner with the very well-renowned law firm Vadia Gandhi, to kindly do the honors. And respected Shri Anoop Nair, a secretary's job is always a very tough job. You're always flying below the radar and doing bulk of the work. And without your support, this evening would certainly not have been possible. May I request Justice TSK's granddaughter, Priya Suryanarayanan, a brilliant electronics engineer, to kindly do the honors. Distinguished senior advocates, members of the legal fraternity, no words will suffice to express our sincere thanks and gratitude to each and every one of you for your presence here. We are truly energized and encouraged by your presence this evening, and we shall always cherish these wonderful moments. The Chacko brothers, Roy Chacko and Romy Chacko, distinguished advocates of the High Court of Kerala and the Supreme Court of India. The TSK Chacko families are like one, have been like one, not now, but for the past 6 decades and a half. It has withstood the test of time. Thank you both ever so much for holding my hands and guiding me every single step of the way. May I request Justice TSK's daughter-in-law, Geeta Shankar, an internationally acclaimed yoga exponent and recently conferred with the title Yoga Acharya by the Government of India, to kindly do the honors. As our chief guest would certainly agree, this evening would certainly not have been possible but for Romy Chacko. Romy, wherever you're hiding, if you can kindly surface, it'll be a great privilege. Please do come on stage. May I request Justice TSK's great-granddaughter, Ragini Nagpal, a young, dynamic, and brilliant lawyer who is doing wonderful pro bono work with iPro in Delhi on child rights, to kindly do the honors. Even last year, I closely worked with Naveen, who was the secretary of the Kerala High Court Advocates Association, and Mr. Sanand Ramakrishnan, distinguished advocate of the Supreme Court. The support I got from each and every one was simply outstanding. I shall always cherish these fond memories. Members of the press, no function and no event can be a success without your presence and your support. Thank you so much for being with us this evening. Last but not the least, our dear friends and well-wishers who have traveled from far. You have braved the weather and come here speaks volumes of your affection for the Justice TSK family. Thank you ever so much for being with us. A huge thank you to Live Law and Bar and Bench for live beaming this evening's program. Before I conclude, may I take your permission to announce this? The Justice TSK family would love to have this oration on an annual basis, of course, in collaboration with the Kerala High Court Advocates Association. Apart from the oration, we would like to institute the Justice T.S. Krishnamurthy Iyer Scholarship to benefit law students. Our father very deeply revered his father, Justice K. Shankara Subbiah, the erstwhile judge of the Travancore High Court. And therefore, the family wishes to institute the Justice K. Shankara Subbiah Scholarship also. The details of both these scholarships will be worked out in consultation with the President and the committee members of the Kerala High Court Advocates Association and implemented. And last but not the least, our young, dynamic MC of the evening, our bright and sprightly, charming Mahesh Bhanu. A big thank you from the bottom of our hearts. May I request Justice TSK's granddaughter, the force, mighty force behind all forces, and a chef par excellence, Usha Balaji Moorthy, to kindly do the honors. Mahesh. And I still have got to say one last line, and that is a huge thank you to Mrs. Shri Viswanathan for her presence here. Truly, we could not have expected anything more for an inaugural oration. Thank you ever so much, ma'am. God bless you all. Godspeed.
Thank you, sir. We express, on behalf of Kerala High Court Advocates Association, we express our profound gratitude to K.M. Joseph, sir, retired Judge, Supreme Court of India. We express our profound gratitude to all the judges, to all the honorable judges of this court who have taken their time off and have graced this occasion with their presence and support. We express a profound gratitude to the members of the bar for your presence and support towards making this event a grand success. Thank you. Thank you all. I request everyone to rise for the national anthem. Thank you.
जनगण मन अधिनायक जय हे भारत भाग्य विधाता पंजाब सिंध गुजरात मराठा द्राविड उत्कल बंगा विंध्य हिमाचल यमुना गंगा उच्चल जलधि तरंगा तव शुभ नामे जागे तव शुभ आशीष मांगे गाये तव जय गाथा जनगण मंगलदायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे। जय हिंद।